all members of the viewing public. Thank you everyone for coming here today at what I recognize as short notice. I've asked to have a word with all of you to speak today to a decision which has just today been delivered by the Judicial Committee of the Privy Council, decision in the case of Balgo bin Maraj against the Cabinet of the Government of Trinidad and Tobago and the Minister of Rural Development and Local Government. And I'm asked to speak today in my capacity as Attorney General, as advisor to the Cabinet, because I consider that this is a matter which is of significance and of importance to all of the citizens of this country. And notwithstanding the fact that it was recently delivered only a couple hours ago, I thought it important that I should speak to the nation so as to assist with a clear understanding of what this judgment has said and what it means, and a clear understanding in the context of what, from my point of view as a lawyer, is fascinating jurisprudence. May I say at the outset that I call this press conference notwithstanding the fact that I have some other commitments today, so I hope that we can go through what I have to say and address such questions as members of the media may have, to allow me to run away at some point to get back to other things that are occupying my attention. Citizens will recall that in July of 2022, certain amendments were made to the Municipal Corporations Act as part of the local government reform, and which were partially proclaimed in November 2022. A majority of the Privy Council, 3 members of the Privy Council of a bench of 5, today have ruled on a point of interpretation relevant to the amendments which were made to the terms of office of councillors and aldermen. That is recorded at paragraph 6 of the judgment of the Privy Council decision, where it is stated that on an appeal against the refusal of interim relief, the Court of Appeal agreed that, having regard to the importance of the case and the seriousness of the issues, the consequences, it would determine the quote-unquote core issue, namely, whether sections 11 and 12 of the Municipal Corporations Act, as amended by the 2022 Act, applied to the incumbent councillors and aldermen, unquote. The Privy Council today has ruled that these amendments did not apply to the incumbent councillors and aldermen. By so finding, the 3 judges in the majority, Lords Richard, Reed, and Hodge, disagreed with the views of the other 5 appeal judges who have heard this matter, that is to say, Lord Briggs and Lord Kitchen of the Privy Council in the minority, and the unanimous Court of Appeal decision of Trinidad and Tobago by Mrs. Justices of Appeal Musai, Lucky, and Aboud. Importantly, all of the judges who have heard this matter have rejected the argument in one voice and unequivocally. That argument claimed by Mr. Balgo bin Maraj that there occurred any breach of the Constitution or of any common law right to vote by the amendments which extended the date for the local government election. The Privy Council, in agreement with the unanimous Court of Appeal decision of Trinidad and Tobago, found at paragraph 20 today in the judgment that a change in the length of the incumbent councillor's terms of office cannot amount to a contravention of the Constitution. The term for which representatives have been elected is important, but an increase by 1 year in the term of incumbent councillors and aldermen does not of itself breach any of the provisions of the Constitution. More than this, the majority of the Privy Council expressly recognized that it was the prerogative of, and I quote, and within the legislative competence of Parliament, paragraph 35 of the judgment, to so extend the term of incumbent councillors, providing sufficiently clear language was used. The only point of difference between the majority ruling and that of the other judges is to the clarity of the language used in achieving the accepted and permissible objective of extending the date for elections. The reasoning of the majority was merely that the amendments which were made, quote, more naturally read as applying to councillors and aldermen elected after the amendments came into force, paragraph 27 of the judgment. This interpretation, however, was expressly disagreed with by the 5 other judges who have heard this matter. At paragraphs 96 through to 99 of the judgment of the Court of Appeal of Trinidad and Tobago, read by Mr. Justice of Appeal Prakash Musai, the Court of Appeal ruled on what it regarded as the plain meaning of Section 11.4 of the Municipal Corporations Act and went on to find unanimously at paragraph 99 of that Court of Appeal judgment that, quote, this court is of the view that the language of the amendments was sufficient to reveal the intent of Parliament. Today, the 18th of May, 2023, the majority of the Privy Council at paragraph 28 of their ruling stated, and I quote, the board does not, however, go as far as to say that the Court of Appeal's reading of the amended sections is not a possible reading. The board accepts that there is a degree of ambiguity if the focus is solely on the language of the proper approach to construction. That is not, however, the proper approach to the construction, nor, to be fair to the Court of Appeal, did they suggest that it was. The court must have regard to the context and purposes of the amendment and the relevant principles and presumptions of statutory construction. I've just quoted from paragraphs 22 to 23 of the majority decision in the Privy Council read by Lord Richards. Any issue of interpretation of legislation, therefore, and these are my words, remains a question of degree and impression, which the distinctly differing views of 8 members of our higher judiciary who have heard this matter profoundly illustrates. Nevertheless, as a responsible government, this government accepts this ruling of the majority of the board, which disagreed with the unanimous Court of Appeal decision and referred to its interpretation of the amendments as applying as it did to the incumbents. I emphasize here today, ladies and gentlemen, that the amendments to the Municipal Corporation Act have been designed to improve the legislative enabling framework within which local government will be implemented for the people of Trinidad and Tobago by their elected representatives so as to better manage their communities. It bears emphasis that nothing in the way of these amendments and nothing in the decision of the Privy Council can support any argument that this government, by these amendments, was seeking to disenfranchise the rights of the citizens of this country to vote their elected representatives into office. I emphasize this because this decision is, of course, one with an undoubted political dimension, and there will be those who will seek to misrepresent the decision that was handed down today in order to make political capital out of that decision. I suggest with respect, and I caution, that any misrepresentation of this judgment will be wrongly a misrepresentation that can border on contempt. So I urge all citizens to take the time to read this judgment carefully, and I would urge the media, in particular the print media. I always love to sit on my veranda on a Sunday morning and pull out a section of one of the daily Sunday papers and read in detail something that is important to me. I would recommend to the daily media, print media, to publish this judgment in full as a pullout in the Sunday newspapers so that the citizens of this country can read this judgment at their leisure and not have to rely on misrepresentations of the judgment by those who will wish to misrepresent what it says so as to make political capital out of it. I underline on behalf of the government that the government accepts those parts of the Privy Council's ruling which rejected the arguments of the Privy Council, of the claimant, that there was any objective by that legislation to defer the election, and any attempt by, as argued by the claimant's arguments, that the amendments were for an unlawful purpose or were effected in breach of the Constitution. The Privy Council has explicitly ruled against that. In light of these express findings, ladies and gentlemen, that the purpose of delaying elections was not unlawful, nor in breach of any constitutional or common law rights, and respecting the interpretation of the amendments as the Privy Council has now ruled, as Attorney General, I have this Privy Council decision under active consideration for the advice which I will be given to the Honorable Prime Minister and the Cabinet in consultation with very learned and accomplished senior counsel of the Trinidad and Tobago Bar. Ladies and gentlemen, citizens all, thank you very much. I will take a few questions.
Attorney General, Julie Brown, TV6 News. In the first instance, Attorney General, does this mean the ruling of the Privy Council that the local government elections need to be called as soon as possible?
As I said towards the end of the statement that I just made, Joel, I have the decision under active consideration. I am consulting with learned senior counsel from whom I am taking advice. The decision was handed down, I think, about 3 hours ago, and I am giving consideration to it for the advice that I will give to the Cabinet. The decision ultimately as to when an election is to be called will be for the Prime Minister.
And also in terms of the extension of the life of the councils by the proclamation of the act and so on that would have been the subject of this ruling, in terms of any decisions made or anything like that, would that have been done with proper authority? Was it properly constituted in that sense or not?
You are asking me to give the advice which I haven't fully considered as yet, Mr. Brown. It's all under consideration. Law is a very deliberate and careful process, the study of law, and particularly against the background of the fact that we've had 8 judges rule on this matter. 5 of them went one way. The 3 Court of Appeal judges unanimously, and the 2 very strong dissenting minority judgments of the Privy Council today, with 3 of them in the Privy Council taking the majority, which we respect. I hope that you would appreciate that it would be irresponsible of me to rush to advice or conclusions without giving careful consideration to all that needs to be considered on this judgment.
Could I ask, because I noticed you've been counting the decisions of the Court of Appeal judges. If the Privy Council is the final court, why then are you returning to the decisions of the Court of Appeal? Isn't it that those decisions are no longer relevant given what the Privy Council has decided?
Thank you, Ms. Tate. The decisions of the Court of Appeal are not irrelevant. And the reason why I have returned to them and I have pointedly referred to them is for the reason that, and when one looks at the judgment, when you read the judgment of the Privy Council, the Privy Council has been very careful to expressly refer to passages out of the Court of Appeal judgment and to applaud those passages. In fact, this afternoon, I think it was, or this morning, when I listened to Lord Richard, I think it was, the judge of the Privy Council who came out for about 3 minutes this morning, it struck me that even in his oral remarks this morning, he was once again referring to the Court of Appeal decision out of this country. So to answer your question, the remarks of the judges of the Court of Appeal are not irrelevant. It is relevant to the extent that their remarks are part of what is referred to in the reasoning process of the Privy Council, and I would respect the fact that to that extent, the remarks of the Court of Appeal, which half of the decision of the Privy Council has agreed with, that is to say, the Court of Appeal rejected the violation claim of the constitutionality of the amendments, and that has been endorsed by the Privy Council, and to that extent, the government has won on that point. I think it is entirely appropriate that I should take this opportunity, as I always do, to applaud the quality of our local judges.
And in reading the judgment, there is a clear reference to the fact that when, and I may be, but a reference to the fact that when people voted in the current group of councillors, it was for a period of 3 years. And if the source of their authority is the electorate, then that period cannot be extended by the parliament or the government. Doesn't that suggest that the Privy Council was saying that the government was attempting in some way? I think I saw the word overreach, or that the government was attempting in some way to, not to usurp, but to ignore the right of the electorate to decide which councillors govern them for the period for which they have been voted in, and not have it just extended en passant in the course of a bill.
Well, to answer your question, if I may, and there was more than one, so I'll try to address it as consistently as I can. The legislation which was being interpreted by the Privy Council was legislation passed by the Parliament of Trinidad and Tobago. So that I do not accept that the interpretation of the Privy Council today can be interpreted to mean that the decision is a decision that speaks to an overreach by the government, because the legislation was passed by a vote of members of the parliament, and ultimately legislation is the will of the parliament. Secondly, I do not accept that there is anything in the judgment in which the Privy Council has said that the government of Trinidad and Tobago usurped anyone's rights. On the contrary, I think they use language quite to the contrary. And therefore, I would recommend that you reread the judgment so as to disabuse yourself of the misunderstanding I think you're laboring under.
Okay. And finally, in this debating this legislation in the parliament, the government at no point, if my recollection is correct, explicitly stated that the effect of this bill would be to extend the life of the councils and the corporations by 1 year.
From the minority judgment of the Privy Council. The Privy Council minority judgment strongly disagreed with the majority. And on the question that you are addressing, and I raise it to make the point in answer to your questions, that this is not a question of political mischief. It is not a question of irresponsible government. It is a question of a reasonable interpretation of language of a piece of legislation. And this is what the minority, which was read by Lord Briggs at paragraph 1, page 18, said. The plain language of section 11.4 of the Municipal Corporations Act, read on its own and in context as part of section 11, uses councillors as including incumbents. Both its language and its functional purpose apply to incumbents for whom election is a past event. And they say that to make the point that on their interpretation of section 11.4, the term councillors was intended by Parliament to include the incumbents, whose term on proclamation therefore became extended to 4 years. That's a reasonable interpretation of a judge of the Privy Council. So the suggestion of mischief and whatever other term I'm being told by you is being used by politicians misinform themselves, and I would recommend that we read the judgment in its entirety. Good afternoon. Yes.
Mr. H, what happens now to the regional bodies? Do they still continue to do their work? Would councillors, aldermen, for example, get paid and will money be allocated to these bodies? You know, seeing that we're now going into the wet season, you know, with rain, you know, there were instances of flooding, etc. Would they continue to operate?
The judgment is under consideration for its true meaning and purpose. The judgment is respected by the government, and this government is a law-abiding government. I expect the government will continue to act responsibly while it gets advice as to the meaning of the judgment as to what it does next.
Do you think that that the Privy Council should have stated that election should have been called or not, you know, immediately, because they seem to be very ambiguous, you know, with that. You know, they didn't say what would be the next step. You know, they just said that the laws that were passed by the government was wrong. Yeah, so then how is that to be interpreted?
Well,
as you go along?
It would be a matter of divine wisdom on my part if I could comment on the possibility of an interpretation of something that the Privy Council has not said. But if I were to address the question that you are asking because you are concerned about it, the point is that the Privy Council has not given an order telling the government what to do. I would expect that that has been the case because the Privy Council is a body of responsible judges, and they understand from the judgment that I have read that this was simply a question of interpreting the legislation and not about ordering the government how to run the country.
And how soon you think you would have advice for Cabinet right on the way forward?
I'm working on it as hard as I can. It's one of the reasons why I have to leave here shortly, because I am in a meeting later today that is addressing considerations arriving from the judgment.
Would part of your considerations, Attorney General, as you seek to advise the Cabinet, include the possibility of any further legislation to deal with anything arising out of the judgment by the Privy Council?
Well, what I'd say to that, Mr. Brown, without preempting myself, is no possibilities are being ruled out. And as a responsible attorney at law, I will take all relevant and rational recommendations into consideration as I meet with the attorneys from whom I'm taking advice going forward from this evening.
And just as a follow-up to that, if there is legislation, because as my colleague would have said earlier, misstated that the Privy Council is the final court of appeal, if there is a legislative solution that will be brought forward, would that in any way go against the ruling of the final court of appeal?
That would be premature of me to say, and it would be disrespectful both of those who will be advising me and of the Privy Council. I would not wish to offer any premature views. Thank you.
Good day, AG. Paula Linder from the Newsday here. I have two questions. Based on the Privy Council's judgment, does the government believe it's necessary to amend the Constitution to fix dates for local government elections.
Can you
and
repeat that? I lost you there. Based on, sorry.
the judgment?
Yes.
Will you be amending the constitution to fix dates for local government elections, and will you seek the support of the opposition to pass such an amendment quickly? And the second question is...
Can I answer that first?
Sure.
I'm not able to answer that question because this judgment was handed down a few hours ago. I have everything under consideration, and I will be giving my advice in due course.
Thank you. My second question is, do you still stand by the decision to issue the proclamation to extend the life of councillors rather than the previous decision of amending the legislation as was done under a previous administration?
Not only do I not understand the question from the background of a previous administration, but what I would say is this: nothing in the judgment criticizes the proclamation that was issued to bring the legislation into effect. In fact, I think to the contrary, the judges respect the fact that the proclamation was issued. The question that arose is, what is the interpretation to be given to the legislation which exists? And therefore, I decline to engage in speculation on something that the court has not ruled. I think it would be imprudent and impertinent of me to engage in that kind of speculation. Ladies and gentlemen, I'm going to have to leave shortly, but I'm happy to take one or two more questions. I don't want to preempt the right of the free press, but I do have to leave shortly.
Just a follow-up, what advice it is you would have for a councillor now? You know, should he be worried about his job? You know, and being paid?
You want me to advise the councillors before I advise the Prime Minister? I can't do that. I'm prepared to, in due course, on the advice that such advice as I give to cabinet, but to ask me what advice I have to give to other persons before I've had time fully to consider this judgment, fully to take into consideration the advice which I will get, which will enable me to advise the cabinet, is, I think, with the greatest of respect, an unfair question that should not lead to a headline.
So is there, for example, now, you know, sort of period of limbo?
The only term of limbo that was used incidentally in this judgment is at page 18 of the judgment, the minority who said, if councillors were to mean only those to be elected at the next election, there would be no statutory provision in the Act at all specifying the term of incumbent councillors. That is a strange vacuum which construction should, if possible, avoid. It's the minority judges of the Privy Council who referred to the concept of vacuum and limbo, and I'm not going to engage that any further. It doesn't arise. Ladies and gentlemen, I am very sorry, but I have other things to do, and if there are no further questions, I would ask you to excuse me.
Is there, how should I put it? Are the systems in place vis-a-vis this legislation to hold an election, well, not immediately, but to hold an election in the shortest possible time?
All of that is under consideration, Ms. State, and on which in due course I am certain I will be able to give advice. Thank you very much. Thank you very much, ladies and gentlemen.